Sitting here on behalf of the plaintiff.
Sir, your name?
Sorry, Judge. Fellas name.
All right, this is the date for non-jury trial, and this is a non-payment of rent case. How much is the plaintiff claim is owing?
The total balance at this time is $3,320.17 plus court costs of $161. $3,320.17.
All right.
Hey, Yana,
Sir, of that amount, is there any that you believe that you owe?
No.
You were going to say something.
Buckle up, guys. Today we're going to step into a courtroom opening that instantly tilts from routine to bizarre. The plaintiff announces a precise monetary claim. The defendant fumbles to state his name and immediately raises an outsized theory about credits instead of lawful payments. The judge's early, plain-spoken questions force the tone, fact-finding over fancy rhetoric. This intro clip is a compact hook, confusion, stakes, and the first legal friction all in under a minute.
I was going to ask to object what he was about to say as far as about the numbers. About saying what I owe, but you already answered the question. Ask me the question.
And Mr.
Break down that amount if you want me to, Your Honor.
Pardon?
I can break down the amount if you'd like me to.
Just one moment, we'll get to that. Sir, can I ask you, I received the documents from you. Is there a reason why you don't think you owe that amount?
Because it's already been paid, Your Honor. Far as reporting adverse information about a co-signer Act 211 of 1989, Vanessa placed.
The plaintiff details ledger totals and court costs while defense language becomes evasive. The clash is visible. Clear accounting on one side, idiosyncratic terms on the other. Counsel offers to break down figures. The defendant insists payments were made via credits and endorsements. The judge pushes for residency and ledger proof. This segment shows a mismatch between documentary clarity and fuzzy, non-standard defenses. A small courtroom storm that foreshadows breakdowns in credibility.
Trying to held me liable as the co-signer when I have an interest and a signature and I'm a natural person. So they're trying to hold liable.
Okay, so let me ask you this.
Okay.
Just so that I have the background on it. You reside in this unit that's at, I think, 315B at 1000. You reside there.
That's my place of abode.
Well, you live there, right?
Depends what you're talking about. I'm acting as a consumer. So, as far as like my, I'm there on special appearance, and my estate stays there. But as far as a natural man, I don't have no.
Here the court moves to sworn testimony and exhibits. The manager and the ledger are introduced. The judge asks targeted questions about prior proceedings and whether rent was actually paid through a previously entered agreement. The defendant claims prior government-funded payments and then retreats into complex provenance claims. This part captures a procedural pivot, where informal claims begin to meet formal evidence rules and the judge demands documentary clarity.
Place. As far as my estate and my...
Okay, so when whoever is in this courtroom leaves here to go to what they would call home, where does this person that's sitting here go?
To my place of abode, Your Honor.
Which is where?
Up in this place.
Okay. At the 315B.
Correct.
All right. That's what I need to know. Okay. Do you have a ledger?
And I'll give Mr. Lane a copy also.
Thank you.
And Mr. Fantera, this would be your witness, is
Yes.
that correct? Okay, why don't we do this? Why don't we have her and Mr. Lane sworn in, please?
Thank you.
Yeah, one is.
The defendant attempts to explain his method, cutting statements, writing pay to the order of, and mailing them as if checks. Counsel identifies third-party billing practices. The judge's questioning sharpens. Is there an actual account, an actual dollar transfer, or merely paper endorsements? This segment exposes a critical evidentiary gap. It's a teachable beat about how courts separate performative paperwork from legally effective payment, and why that distinction matters.
Right hand. Swear affirm the testimony you're about to give.
I do.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your Honor, could I give you real quick context on that?
Yes, please.
We had a previous case last summer where Mr. Lane received Sarah funds. And when we had the, I have a copy, I have a case number, I have a copy of the unsigned copy of the COD. That was entered on September 9th. SOS paid his rent through September, and it left a small balance of, I think about $119, which we waived. So the balance, even though it doesn't show it on.
The exchange tightens as the judge repeatedly asks whether the defendant paid anything in U.S. dollars or via a traditional financial instrument. The defendant replies with claims of credits and interest in a so-called trust. The judge demands proof of any account balance. Watch the defendant's inability to show a concrete balance become the moment credibility starts to erode. This clip compresses the moment theory begins to collapse against basic transactional proof requirements.
There because we didn't actually get the SOS check till sometime later. His rent at the end of September was $0.
Got it.
So the total balance that's on there is 5 months of rent at $513 each, water and sewer bills, electric bills. There's not even any late fees, and then there's 161 in court costs. So I just want to clarify that, in fact, none of this goes back past September 30th. In fact, I don't know if you remember, we actually, when we had the previous case, Mr. Lane had sued Peninsula Place seeking the return of all money he paid forever. And he denied that he owed money, but simultaneously applied for Sarah, and he denied he applied for Sarah.
Objections and clarifying questions punctuate this slice. Counsel presses a defendant for where a landlord would take his paper to extract U.S. dollars. The defendant offers vague answers about treasuries and trusts. The judge refuses hypotheticals and keeps returning to admissible evidence standards. This back and forth demonstrates the court's commitment to practical, verifiable facts and the danger relying on metaphysical or sovereign-sounding claims when real liabilities are at issue.
Verified with probably Aaron at the time that he had applied for Sarah. He ended up getting Sarah funds. He would not sign the COD, and then you basically gave him a choice. I'll enter the COD, or we'll have a trial and I'll give you a judgment. But it sounds like he's raising some of the same stuff now that he attempted to raise.
Your Honor, free to speak?
Go ahead, sir.
So, Your Honor, when I applied at first I didn't know what I was applying for. So when I applied for Sarah funding, I ended up giving my principal information, which was my name, my date of birth, and my social security number. Basically, I'm here today saying that I gave my principal to Peninsula Place, and I've never received
A subtle escalation. The defendant doubles down on grand claims, billion-dollar lines of credit tied to personal documents, while the court remains unimpressed. The judge methodically frames the issue: actual payment versus claimed endorsements. The manager's ledger remains unrebutted. This segment is dramatic because it marks the moment the courtroom majority starts treating the defendant's narrative as legally irrelevant, setting the stage for a decisive ruling.
in consideration.
Your Honor, I don't understand what that means.
I again, I don't know what that means. However, are you Trellis Lane? That's a yes or no. Because I'll tell you, if you are, then we'll go ahead with the trial. If you're not Trellis Lane, then I'm going to give them a judgment by default because Trellis Lane hasn't shown.
I'm here on special appearance.
No, you can't do that. You are not an attorney at law because you can't appear for somebody else. So my question is, and I'll ask it again, are you Trellis Lane?
Yes, Your Honor.
Thank you. So, Mr. Lane, October of 2022, did you...
Tension peaks as the judge demands specificity. Name the account, show the balance. Explain where one would collect U.S. dollars. The defendant struggles with specifics and resorts to abstract premises about trust locations and presidential-era monetary changes. The formality of questioning strips the argument of its mystique. This portion reads like a dismantling. The judge's short, relentless questions puncture legal smoke and reveal the absence of admissible support for the defense.
Pay rent to the landlord.
Yes, Your Honor.
Okay, and how did you pay that?
I'm paying with my credits that's on file. So I sent instructions back in May, basically to get my account zero every month.
To do what?
I sent instructions back in May, then I sent another one to December to the CEO.
The CEO of what?
American Campus Committees. Saying it right. So he's seen my email, so he's aware of what's going on. Basically, like I say, I'm looking for consideration. I have not been getting no consideration, no adequate consideration.
Well, you get adequate consideration for the contract.
Now the conversation turns to statutory defenses and procedural posture. The defendant invokes consumer protection and landlord-tenant doctrines without identifying concrete provisions or facts that would apply. The judge tests each claim against a record and the contract's basic obligations. This clip is instructive. Courtroom law is a rhetorical playground. Statutes require concrete elements, and speculative assertions don't substitute for them. Expect the judge to start moving toward resolution here.
In any payment by virtue of the fact that you have a residence. So I don't think consideration is even an issue.
But yeah, I have several questions.
Well, you can go ahead and ask your questions, but I don't know. Let me just ask this. October 2022, how did you pay your rent?
I paid with my took the bill, I endorsed it.
Did you give them cash?
We don't have,
We being whom?
I'm saying it's a credit system, Your Honor.
It's a what?
Credit system. We don't.
So who's in charge of this credit system?
You said who's in charge?
Surely.
I mean, we haven't had money since.
The manager, sworn, reaffirms the ledger totals and a lack of any security deposit or adequate offsets. The defendant reiterates that his portal shows a positive balance, but cannot translate that into a lawful payment or proof. The judge contrasts lived possession, the consideration received, with the absence of lawful tender. This section crystallizes the practical question. Did the landlord receive lawful payment? The answer begins to harden into no.
1933, the Marriage and Bacon Act.
We being whom?
As
Who are you talking about when you say we haven't had money? Who is we?
far as like the United States haven't had money since 19.
Oh, they definitely have, and I spent my share. So I don't know. You're saying you gave them credit.
Yes.
In what form did you give them credit in the month of October 2022?
Then credit, I took the bill, which they give me a bill every month, which is a statement. I take the statement. If you want to, I can show you what I'm doing.
I know what he's referring to. Can I show you?
Yeah.
Well, show him, and then
I got copies for him. Here's what he's getting, Your Honor. We have a third-party billing company called Zigo.
Appointed court moment. The judge asks for a list of reasons why judgment should not be entered, and the defendant offers federal-sounding objections rather than direct transactional proof. The courtroom dynamic tilts decidedly. The judge signals exhaustion with abstract claims and reiterates the need for verifiable evidence. This clip carries a feeling that the result is imminent. The judge's patience has narrowed to procedural essentials that the defense cannot meet.
And so what they do is every month they bill the utilities. So he gets this bill, and then you'll see at the bottom what he writes is pay to the order of Peninsula Place. And so what he's taken, so for example, the top one says pay to the order of Peninsula Place, $662.12. That amount is his monthly rent plus the $123.12 in utilities that are at the top. There's 3 of these that I've attacked. So what he does is he cuts off the bottom and he mails that in as with instructions to pay to the order of Peninsula Place as if that's a check.
Have this marked as plaintiff's exhibit and 2. The ledger being 1.
Procedure and final clarity. The court addresses jury trial waivers, prior rulings, and whether the defendant properly preserved any objections. These technical questions underscore that many tactical defenses were never raised timely or with proper grounding. The judge's procedural rulings compress the remaining avenues for relief. Use this clip to show how procedural posture can decide a case as much as contested facts when offenses aren't coherently presented.
Mr. Lane, you have a copy of what I've marked as Plaintiff's Exhibit 2. Is what Mr. Fantera described, is that correct? Is that what you do?
Yes, I'm accepting the credits that's given to me, and I'm transferring it back.
Who's giving you this credit? They who?
So Nessa Place, so in the beginning, when I signed up with Nessa Place, I gave my credit information. So those payments are supposed to come to me as credit. So
what payments?
The payments that's coming every month. So those payments, they're trying to hold me liable for it, and I'm taking the credits that I'm receiving in addition.
The closing moments of testimony and counsel's foregoing of a closing argument produce a sense of inevitability. The defendant again hints at federal appeals, but the record is clear. The ledger, the manager's testimony, and the absence of U.S. dollar payments are uncontroverted. This part distills the hearing's logic. The court resolves disputes by reference to admissible proof, not visionary financial theories, making the judgment's calculus plain.
Back to Peninsula Place.
Who's giving you credit?
You said who's giving me credit?
Yeah.
I have credit, Your Honor. I have a security interest.
In what?
And this so-called contract with Peninsula Place.
Okay, but who's giving you credit? Young man, you keep using these terms, payment, credit, and it seems to me as I'm listening to you that you're using them improperly. So my question is, have you paid anything to the plaintiff in U.S. dollars or anything that evidences U.S. dollars?
No, I haven't paid in U.S. dollars.
Or anything evidencing U.S. dollars, like a...
All right, guys, the finale. The court finds the plaintiff. Judgment entered for $3,320.17 plus costs, a 10-day redemption window, and potential eviction steps if unpaid. The gavel fall is both banal and consequential, a small-sum financial ruling that carries severe real-world consequences. This last commentary wraps the story, contrasts theatrical defense claims with concrete legal outcomes, and reminds viewers that courtroom procedure and evidence, not rhetoric, ultimately decide results. Like the video and subscribe to the channel, and we'll see you in the next video.